Good morning and welcome to Gough Square Live. My name is George Spence-Jones. I'm a barrister at Gough Square Chambers, practicing in consumer and trading standards law. Today I'm going to be talking about the offences relating to consent, connivance and neglect, often referred to as directors' liability offences. The aim of my talk today, which will last about 15 minutes, is to give a high-level overview of the main principles of the offences which relate to consent, connivance and neglect that may apply to directors or senior corporate individuals. I imagine that many of you will already have some familiarity with these offences from being involved with prosecutions or individuals, as well as for corporations for regulatory crimes, or maybe even being instructed to defend a director who was sitting alongside their company that was facing prosecution. Alternatively, you may simply have seen the various statutory regimes, the provisions, that would include the option to pursue certain individuals if consent, connivance or neglect apply. We will mainly be looking at, firstly, who are these offences directed at, and then secondly, what you want to be on the lookout for. Some key principles and authorities will be set out on the slides for you to jot down. As in previous Gough Square Lives, I won't be answering any questions on air, and we'll try to keep the whole talk to under 20 minutes. But do still feel free to email us later if you have any questions. So to begin with, the general position is that when considering who's criminally liable or responsible for something done or not done, you'll first look at the trader, the business. Very often that is the limited company, that is, for example, the contracting party or the relevant food business operator. It also might be a sole trader, but today we're just dealing with corporations, or a body corporate as it is often termed in the statutes. Now, during your investigation, you may also find that a senior individual at the company seems to have a part to play in bringing about the relevant offence. It is at this point that you want to consider the director's liability offences of consent, connivance and neglect. On the slide in the small text towards the bottom is an example from Regulation 15.1 of the Consumer Protection from Unfair Trading Regulations 2008. The important starting point, looking at the first line of that provision, is that you will need to prove the primary offence against the body corporate. For example, that might be a misleading action or contravening professional diligence. So don't forget to obtain the evidence for all those elements first. On an aside, you might be thinking, if the company is no longer in existence, you'll still have to prove at trial that the primary offence was committed by the company, even if you do not charge that company, for example, because they're wound up. And when considering the liability of the company, you'll need to consider the due diligence defences, as those will be deployed to prevent the company from being liable in the first instance. To assist with that, you can review one of Gough Square Live's earlier videos on due diligence. Now, if on the other hand the company is still in existence, it's typical to have the company prosecuted as a co-defendant and charged with the primary offence, even if your aim is really just to pursue a particular director. But it all might depend on the facts of the case. But back to today's talk. Once you have your evidence in relation to the company first committing the primary offence, and you have considered whether the company will benefit from a due diligence defence, if that is relevant, you can then consider the role of the particular individual. What you are looking for is, and you can look at the subsections A and B on the slide in front of you, consent by that individual to the commission of the offence by the company, or connivance by that individual to the commission of the offence by the company, or the commission of the offence by the company is attributable to any neglect on the part of that individual. As usual, the prosecution will have the burden to prove these elements, and the standard is the same, so that your tribunal of fact is sure. In terms of charging decisions, it's often sensible to split the mode of liability, so neglect is typically charged separately to consent or to connivance, but advice can be taken on that if in any doubt. In terms of your sentencing, the provision will usually give you more detail of the consequences for a director's liability, but here we can see that the officer is guilty of the offence too, is liable to prosecution, and is then punished accordingly. So the statute removes the protection of the corporation and exposes that individual to prosecution and sentence as if they were a sole trader business, for example. Finally, there will often be sentencing guidelines for individuals that are different, as corporations face fines, typically, but individuals can face imprisonment. Now, on to the who. The starting point is usually the list of individuals that is set out in the statute. It often looks like what you can see on the slide in front of you. Towards the top of the slide is Regulation 15.2 of those 2008 regulations, and at the end of the provision, after the long list, you can see the words other similar officer. So the list is not exhaustive. And the key point here on this slide is the guidance from the courts on this list. It comes from the case of Crown and Bowl, and the focus is the position of real authority. The intended scope of consent, connivance and neglect offences was to fix with criminal liability only those who are in a position of real authority, the decision makers within the company, who have both the power and responsibility to decide corporate policy and strategy. It is to catch those responsible for putting proper procedures in place. It is not meant to strike at underlings. That case concerned an assistant manager of a bookshop. They did not have the management of the whole affairs of the company. They were not entrusted with power to transact the whole affairs of the company. So the Court of Appeal quashed their conviction for directors' liability. They also noted that the focus is on those with functions of management. So that is the who to look for. Once you're satisfied that your individual falls within the scope or the list of right individuals, you then move to what is their involvement in the commission of the offence. Let's start with whether they have consented. You are looking for actual knowledge and agreement to a state of affairs by the defendant. This comes from the case of Chargot. The prosecution must prove that the defendant knew the material facts which constitute the offence by the body corporate and agreed to its conduct of business on the basis of those facts. And the citation for that proposition is set out on the slide. The assessment is fact-specific. In Chargot, an employee was tasked with driving a dumper truck of soil on the farm. That employee had to leave work urgently due to family issues, and so another employee was asked by the foreman to step in. They did. Unfortunately, something happened during the unloading. They don't really know what, but the employee wasn't wearing his seatbelt. There was an accident, and he passed away. The principal contracting company was then charged with Health and Safety at Work Act offences. The investigation found various shortcomings in health and safety organisation on the farm. Also, the managing director of that principal contractor was charged with consent, connivance and neglect offences under the Health and Safety at Work Act. The prosecution's case was that the managing director was that he was directly involved in the works, gave specific instructions as to how they were to be performed, and generally on the farm he made most of the decisions. So the only sensible inference was that if the company committed the offence, the managing director had willingly allowed that, or had turned a blind eye to its commission. That sufficed, as the jury convicted the company and the managing director. There were appeals to the Court of Appeal and the House of Lords, but those were dismissed. So in that case, the managing director was held to seemingly know of the state of affairs, direct the operations, and so knew of the shortcomings which amounted to the breach of the Health and Safety at Work Act provisions. Hence, he ultimately had consented to the offence. As discussed, all cases are fact-specific, but that gives you a flavour for what might amount to consent. Moving on now to connivance, which has some overlap with consent. But as you can see from the slide, the focus is the prosecution is to prove that the defendant was well aware of what was going on, but their agreement was tacit, not actively encouraging what was happening, but letting it continue and saying nothing about it. So it is an implied or an understood agreement to the commission of the offence. Back to the case of Chargot, that case was more about consent, but there was guidance on connivance too. The case noted a failure to meet the requirements of sections 2 and 3 of the Health and Safety at Work Act would mean that there was only a short step to prove the connivance or neglect if the circumstances under which the risk arose were under the direction or control of the officer. So if that director was aware of the circumstances and was letting them continue while saying nothing, that's possibly connivance. Connivance is said to be less common, but it may still be relevant. It just depends on the facts of your case. But now on to neglect. The main aspect here, and the main takeaway from this one is it is the most relevant, most common mode of pursuing director's liability. And why? Because it has the lower mens rea threshold than consent or connivance. Because what you can see from the propositions here is the key question is, did the director fail to do something that reasonably ought to have been done to prevent the commission of the offence? So it is framed in terms of duties, scopes of duties, breaches of duties, and then causation. Very familiar concepts to most lawyers. But as we move on to look at it in more detail, there are a few key concepts to consider and remember. First of all, Delegation. Can you delegate your responsibilities? Yes, but it is fact specific. You cannot just absent yourself from all your responsibilities. The framing is again what the defendant reasonably ought to have done. The case we're concerned with is Huckabee, providing useful guidance. In that case, the company was guilty of allowing gaming on premises to take place without a license. The first director consented to this and they had pleaded guilty. A second director, though, was then pursued under the neglect mode of the offence. From an interview with authorities, it was clear that that second director knew little of the conduct of the premises in question. It was left in the hands of the first director, the one who'd pleaded guilty to consent. And although the second director was aware that a gaming licence was required, and she knew that money had been made available for licences, she had no knowledge whether or not the gaming licence for the premises had actually been obtained. There was no further evidence in the prosecution. At first instance, the magistrates convicted, but the appeal was allowed, and on appeal the court held that the prosecution had actually failed to show that the offence was attributable to any neglect on the part of the appellant's second director, for a director can properly leave certain matters to other directors or officials of the company. The second director had left licences for the first director to deal with, and on the evidence she had no reason to distrust him, and she could not be said to have neglected her duty merely because she failed to make a specific inquiry in relation to whether a gaming licence had been obtained. So they had delegated to the first director the matter of the licences. So the questions to ask here, as with all of your investigations, will be: are there reasons that one director should distrust another? Have they delegated something? Are they on notice of any issue on their delegation that they should be investigating? Then we consider the second proposition. Is there a duty to control the affairs of your company? Generally, no. Again, back to Huckabee, the case of Huckabee, for guidance on this matter. This second director did not have a general duty to control or supervise the running of the company. There was another director in place too. The second director didn't have to acquaint themselves with all the details of the company. That proposition from the court was seemingly in reference to whether the second director should have checked if the licence was in fact applied for and or obtained, and she didn't have to. Evidently this is a fact-specific assessment, but it is useful to have in mind that the starting point is there is no general duty to control or supervise all the details of your company. It is a question of degree and will depend on the circumstances of the company. Finally, and an often difficult aspect to consider, is: are the steps identified within this defendant's scope? Often it might be easy to point to a reasonable step that should have been taken, but the difficulty is connecting that step to something specifically this defendant, the specific director or senior individual, should have done. The case of Wotherspoon is particularly useful on this matter, and it says the focus is a step which expressly falls or should be held to fall within the scope of the functions of the office which he holds. Now this is likely more straightforward for smaller companies, but it will become increasingly more difficult with larger companies that have multiple senior officers. It is highly fact-specific. In Wotherspoon, it was a straightforward case about an absence of adequate fencing surrounding a particular machine and health and safety at work offences. The managing director was found guilty of neglect. The jury did not have difficulty inferring that he was the one who had the responsibility to ensure the machinery was properly fenced off. But there was a fellow director who was prosecuted, and they were just a director. He was acquitted. The jury evidently looked at the hierarchy of senior officers, and they found that the buck stopped with the managing director and the managing director only. On a final note, from also the case of Wotherspoon, it is any degree of attributability would suffice for neglect. So the jury did not have to find that the managing director was the only one with responsibility, and it is up to the jury and the particular facts and circumstances of a case. Thank you for listening in. Hopefully today's talk has provided you with a useful overview of directors' liability and then consent, connivance and neglect offences. Please feel free to get in touch with us by email with any queries, and we will try our best to provide you with an answer. And finally, please tune in to our next instalment of Goss Square Live, which will be in April 2024, with my colleague Stuart Jessup, and I think the topic is to be announced in due course. Thank you, and goodbye from me.